Welcome employers. Today we'll discuss how to handle an ACAS early conciliation when you receive a call or email notification. Understanding early conciliation. Early conciliation is when the Advisory Conciliation and Arbitration Service, ACAS, talks to both parties about a workplace dispute. It aims to resolve issues before they escalate to an employment tribunal. Don't panic if you receive correspondence from ACAS. Let me explain what happens. Workplace dispute. If your employees have a workplace dispute with you, it's a good idea to try to resolve it informally first. They should raise the problem with their line manager or submit a formal grievance, and you should follow your grievance procedure to deal with it properly. While this step isn't mandatory for them making an employment tribunal claim, it could help you both to resolve the dispute without going to court, saving a lot of time and money. If the employee decides to proceed with the claim, they must inform ACAS before taking any further steps. Remember, there is nothing to stop them submitting a claim, regardless of the true validity of their dispute. Early conciliation. When your employee tells ACAS that they want to make an employment tribunal claim, they offer what is known as early conciliation. During early conciliation, ACAS talks to both the employee, the claimant, and the respondent, you, about the dispute. The goal is to reach an agreement without going to tribunal. Please be aware that ACAS is not part of the tribunal service and does not discuss any matters with the tribunal itself. It's also worth noting that initially they do not advise on whether the claim would be successful, as they only have the employee's version of events at this stage. Benefits of early conciliation. It's free, it's confidential, it's quicker than going to tribunal, it's easier, less paperwork compared to a tribunal, it's voluntary, you or the claimant can refuse talks, you can agree on the outcomes that may not be available through a tribunal, e.g. a job reference. It's advance warning that a potential tribunal claim is heading your way. Or, a less well-known fact, you as an employer can request talks through ACAS if you think a dispute with an employee could lead to a tribunal. Your role as an employer. Respond promptly. Be aware that you have 28 days to respond to an ACAS early conciliation, so don't bury your head in the sand and hope that it will all go away. It won't. ACAS is impartial, which means they're not on either side. They're there to help resolve the dispute without going to an employment tribunal. It's worth engaging with ACAS to understand the nature of the dispute. Learn what outcome the employee is hoping for, which can often be a financial settlement. What ACAS conciliators do. A conciliator will explain the conciliation process, discuss issues with both sides, give an overview of the law, discuss how employment tribunals have considered cases similar to this one, help both sides explore strengths and weaknesses of the case, discuss possible options without making any recommendations, remain independent of the dispute. They will not take sides or tell you what to do. Outline the employment tribunal process. Reaching an agreement. Once you and the claimant reach an agreement, ACAS will write up what you agree in a settlement form called a COT3. This is a settlement agreement. It's important that it's right for you. Once you and the claimant agrees it, you'll have to keep it, even if you have not yet signed it. A settlement is legally binding. ACAS will organise yours and the claimant's signature. Your employee will not be able to take their case to tribunal if the case is settled in early conciliation, even if they have already made a tribunal claim. The case will be closed and there will be no hearing. No agreement. It is important to remember that you do not have to accept the employee's claim, and you do not have to agree to a financial settlement. After early conciliation, we'll give the employee a certificate. They need this certificate to progress with an employment tribunal claim, and we'll need to add the certificate number to a form known as ET1. The employee will have a minimum of 1 calendar month from the date of receipt of the certificate to make the claim. You and the employee can continue talking through ACAS up to and including the tribunal until a judgment is made. This is known as conciliation. It is also worth noting that the tribunal service does not validate the claim upon accepting it. Conclusion. The best advice we can offer is to make sure that you treat all of your employees fairly and consistently. If you do have any workplace disputes, make sure you deal with them in a timely manner, making sure you follow your own policies and procedures. Keep full records of all communications and meeting notes. You will need these if a claim did end up in an employment tribunal. These steps will ensure that you are in the best position to defend any potential claim. Remember that ACAS aims for resolution. Be cooperative, transparent and respectful, and don't panic.